The day my son handed me a pen and asked me to sign my name, I looked at his eyes and saw a stranger. Not the boy I had coached through Little League on Saturday mornings. Not the young man I had driven to college with a truck full of furniture and a heart full of pride. The man standing in front of me that afternoon, in the dining room of the house I had built with my own 2 hands, was someone I did not recognize at all. And the worst part, the part that still sits heavy in my chest when I think about it, is that I signed anyway. That was 3 years ago. I am 64 years old now, and I am sitting in a lawn chair on the back porch of a rented cottage in Asheville, North Carolina, watching the Blue Ridge Mountains turn orange in the late afternoon light. I have a cup of coffee in my hand and a folder on the table beside me. That folder contains documents that will, by this time next week, remove my son from the company I spent 31 years building from nothing. It will reverse every financial maneuver he made in the 14 months I was gone, and it will expose, in full legal detail, exactly what he and his wife did to put me away. I want to tell you how we got here. I think you need to hear it. My name is not important, but my story is. I worked in commercial plumbing, contracting my entire adult life. I started as a laborer at 22, pulling pipe in new construction in Charlotte, sweating through summers that felt like standing inside a furnace. By the time I was 30, I had my contractor's license. By 35, I had my first crew. By 45, I had a company with 63 employees, 3 divisions, and contracts with hospital systems, school districts, and commercial developers across the Carolinas. I named it after my father, who died before he ever saw what I built. That mattered to me more than I can explain. My wife passed 11 years ago. Breast cancer. She was 51 years old. She was the smartest, toughest, most quietly funny person I have ever known. And when she died, something inside me that had always run warm went very cold for a long time. I kept working because it was the only thing I knew how to do. My son was 26 at the time. He was already working in the company, handling, estimating, and client relations. He was good at it, charming. People liked him. I thought I was building something that would outlast me, something I could hand to him the way you hand a man a torch and trust him to carry it forward. I should have paid more attention to the flame. He married his wife about 4 years after his mother died. She was pleasant enough at first, organized, sharp, always asking questions about the business that I chalked up to genuine interest. She had grown up wealthy, or at least she presented herself that way, and she had opinions about how things should be done that she shared freely and often. I did not take it personally. A lot of young people come into an established business thinking they see inefficiencies the founder is too stubborn to fix. Sometimes they are right. I tried to listen. What I did not see, because I did not want to see it, was the degree to which my son had stopped being my son and started being her husband in the way that means you belong entirely to another person. Every conversation I had with him began feeling like a conversation I was having with a relay station. I would say something at the office on Monday, and by Thursday his wife would bring it up at dinner with an angle on it I had not intended. Small things, subtle things, the kind of things you can dismiss as coincidence, until one day you have collected enough of them that coincidence no longer covers it. The shift became impossible to ignore the summer, before everything fell apart. I had been considering restructuring the ownership of the company. I was 61, and my financial advisor had suggested it was time to formalize a succession plan. We discussed several options, including an employee stock ownership plan that would allow key long-term employees to hold stakes alongside my son. I thought it was fair. I thought it honored the people who had helped build what we had. I made the mistake of sharing this idea at a family dinner, casually. The way you share an idea you are still turning over in your mind. My son's reaction was calm. His wife's was also calm. That was when I should have paid attention. Neither of them pushed back. They just listened, nodded, and changed the subject. I thought they agreed. I understand now that they were simply moving to the next part of a plan they had already written. Over the following weeks, my son began suggesting I see a doctor about what he described as my increasing forgetfulness. He mentioned it twice at work, in front of staff. His wife mentioned it at a family dinner, tilting her head with the kind of concern that photographs well but means nothing. I thought back and could not identify what they were referring to. I had lost my keys once. I had forgotten a lunch meeting and rescheduled it. I was 61 years old, running a company, and I had missed a lunch. That was the entirety of their evidence. But they were not building a medical case. They were building a perception. There is a difference, and I did not understand it until it was too late. In October of that year, I had a minor car accident. I was pulling out of a parking deck downtown and clipped a concrete pillar. Nobody was hurt. The car had a dent the size of a dinner plate. Under ordinary circumstances, it would have been a Tuesday. But my son was in the passenger seat, and within 48 hours he had contacted my physician, my attorney, and my two closest friends, all of whom he had already been quietly cultivating for months, and told them he was worried about my cognitive health and physical safety. He used the words, "It's getting worse." He said it with tears in his eyes, according to one friend who called me afterward, clearly shaken. I did not know any of this was happening. I was at the office, working. The document he handed me that afternoon in November was a durable power of attorney combined with a healthcare proxy. He told me it was something the family attorney had recommended as basic estate planning. He told me it was standard. He told me it was nothing to worry about. I was tired. I had just come from a long meeting with a hospital contractor who had been pushing back on change orders for 3 weeks. I sat down at my own dining room table, and I signed my name on a document that handed my son the legal authority to make financial and medical decisions on my behalf if I was determined to be incapacitated. 2 months later, he used that document to have me admitted to a memory care facility in Raleigh. I want you to understand what that sentence means. It does not mean I was taken there against my will in some dramatic scene. It means that on a Tuesday morning in January, my son and his wife and a physician I had seen exactly twice came to my home, and within 4 hours I was in a car, and then I was in a room, and then the door was closed, and I was inside. The facility was clean. The staff were not unkind. None of that is the point. The point is that I was a 61-year-old man with no diagnosis, no history of cognitive impairment, no psychiatric evaluation, and no court order. What I had was a son who had prepared the ground carefully and a legal instrument that gave him the power to act. What I also had, and this is the part I need you to hold on to, was a brother. My brother is 8 years younger than me. He lives in Knoxville. He and my son had never been close. Something about a disagreement at a family gathering years ago that I had never fully understood, and because of that distance, my son had not thought to include him in the circle of people he spent months softening up. My son had spoken to my friends. He had spoken to my employees. He had managed my doctor and my lawyer, but he had not managed my brother, because he had underestimated him, and that was the only mistake he needed to make. The second day I was in that facility, I used the phone in the common room to call my brother. I told him where I was. I told him how I got there. I told him what I had signed. He listened without interrupting, which is something he has always been able to do. When I finished, he was quiet for a moment, and then he said, simply, "Okay, don't sign anything else. I'll handle it." He drove to Raleigh the next morning. What followed over the next 14 months was a legal process that I can only describe as slow, expensive, and ultimately, completely effective. My brother retained an elder law attorney and a litigation firm in Charlotte. They filed a petition to have the power of attorney invalidated on the grounds that I had signed it without adequate explanation of its scope and without independent legal counsel. They commissioned an independent neuropsychological evaluation, performed by a physician my son had never spoken to, which found no evidence of cognitive impairment of any kind. They obtained my medical records and discovered that the physician who had signed the incapacity declaration had done so based almost entirely on written documentation provided by my son and had spent fewer than 30 minutes with me across 2 visits. The process took 14 months because my son fought it. He hired attorneys. He filed counter motions. He told the court that I was a danger to myself and to the company. He told my employees I was sick. He restructured 2 of the company's main contracts to move funds through a subsidiary that he had quietly incorporated in Delaware 6 months before any of this began. He was thorough. I will give him that. He had thought about this for a long time. What he had not thought about was the filing cabinet in my office at the company. I have always kept paper copies of everything. My son found this habit old-fashioned and slightly embarrassing. He had moved the company to a digital document management system 3 years prior, and he believed the physical records were redundant. He was right that they were redundant. He was wrong about what that meant. While he was reorganizing digital records and adjusting contract terms and moving money through Delaware, he left my filing cabinet exactly where it was, in the back corner of my office, because he believed it contained nothing that mattered. It contained 14 years of original contracts, including the founding documents of the Delaware subsidiary, which I had been shown and had quietly photographed with my phone on the one occasion I was allowed a supervised visit to the office. 4 months into my stay at the facility, it contained correspondence between my son and his wife dating back 2 years before the power of attorney was signed, which my brother's attorneys obtained through discovery. It contained, among other things, an email in which my son's wife wrote to him, "The ESOP idea will dilute everything. We need him out before he moves forward with it." That email was dated 6 weeks before my son first mentioned to my doctor that he was worried about my memory. I was released from the facility on a Thursday in March. My brother drove me. We did not speak much on the way back. The mountains were still brown that time of year, not yet turned green, and I watched them through the window and thought about what 14 months of my life looked like, measured against what I still had left. I was 63. I was not sick. I was still myself. My son called me that evening. I did not answer. I have not spoken to him since. I want to be precise about what I did not do when I came home. I did not call a press conference. I did not post anything online. I did not call my employees into a meeting and deliver a speech. I went back to my cottage. I had sold the house while I was in the facility, or rather, my son had sold it on my behalf using the power of attorney, a transaction that is now part of the litigation, and I sat down with my brother and my attorney, and I did what I had spent 14 months thinking about doing. I invoked the provisions of my original shareholder agreement, which predated every document my son had touched. That agreement, drafted when I first brought him into the company as a minority shareholder at age 28, contained a clause stipulating that any attempt by a shareholder to acquire additional control through legal mechanisms rather than agreed purchase was grounds for forced buyout at original valuation. My attorneys had found it. My son's attorneys had apparently missed it, or assumed it was unenforceable. They were wrong. I also filed a civil complaint against my son and his wife for financial elder abuse, fraudulent misrepresentation, and breach of fiduciary duty. The elder abuse statute in North Carolina carries significant penalties. The complaint names the physician who signed the incapacity declaration as a secondary respondent. The Delaware subsidiary has been frozen pending investigation of the contract restructuring. 2 of the employees my son promoted during my absence, people who had participated in the documentation process that supported his narrative, have been let go. I have been asked, by more than one person, whether I am angry. The question always surprises me a little. I think people expect me to say yes, and they expect a particular kind of yes, hot and loud, the kind that fills a room. But what I feel is not exactly that. What I feel is something colder and more permanent. It is the feeling of having had something precious treated as worthless by someone who should have known its value better than anyone. I loved my son. I built a company for him. I imagined him at my funeral, standing at the front of the room, carrying forward something I had poured my whole adult life into. I had imagined it so many times that I had almost made it real. And he looked at all of that, and he saw a problem to be solved. I do not know what his wife told him to make him into the man who stood in my dining room with that pen. I have thought about it many times. I do not think she made him into anything he was not already capable of becoming. She may have accelerated it. She may have provided the strategy. But a man who will put his father in a memory care facility to protect a company inheritance does not get that way overnight, and does not get that way because of one woman. He gets that way because of 1,000 small decisions, each one a little worse than the last, until one day the distance between who he is and who he should be is so vast that there is no way back across it. I think about his mother sometimes when I think about all of this. I think about what she would say if she could see it. I do not think she would be surprised, which is a thought that brings me no comfort and a strange kind of permission at the same time. The company will survive this. I have good people, and most of them never believed what my son told them about me. They were simply too afraid of him to say so while he was in control. Several of them have come to see me since I came home. One man, who has been with me for 22 years, sat in my kitchen and cried. He said he had known something was wrong from the beginning and had not known what to do. I told him I did not blame him, and I meant it. I have hired a new general manager, a woman from Greensboro who has spent 15 years running operations for a mid-sized mechanical contractor and who has, in 3 months, already identified 2 process improvements I had missed for years. I am back in the office 4 days a week. I shake hands with the people who were there before and I learn the names of the people who were hired while I was gone. It is the same company, and it is a different company at the same time. I think about my father's name on the side of the trucks, and I think about whether legacy is something you give to someone or something that simply endures or doesn't based on its own weight. I think it endures. There is a hearing scheduled for the end of this month. My attorneys will present the shareholder agreement provisions and the financial forensics report. My son's attorneys have filed a motion to delay it, which has been denied. His wife's family, who provided some of the initial capital for the Delaware subsidiary, has retained separate counsel, which tells you something about the direction things are moving. The physician who signed the incapacity declaration has agreed to cooperate with investigators in exchange for reduced liability. I did not enjoy hearing that, not because I wanted him to face the full consequences, but because what it means is that he was not a victim of my son's deception. He was a participant in it. He looked at a healthy 61-year-old man and signed his name to a document that locked him away because someone asked him to and the money was right. There are days when that is the part that sits heaviest. I am not a man who talks easily about grief. I grew up in a house where you fixed things, you worked through things, you moved forward. Sitting with a feeling was not something the men in my family did well or often. But I have had 14 months of sitting with feelings, with very little else to do, and what I can tell you is this: betrayal from a stranger is a wound. Betrayal from your own child is an amputation. You do not recover from it the way you recover from a wound. You learn to walk differently. You learn what you can still do and what you have to do without. I miss the son I thought I had. That sounds strange, given everything, but it is the truth. I miss the boy at Little League. I miss the young man in the truck cab, nervous about college, pretending he wasn't. I miss the person I believed he was for 35 years, and the future I believed we were building together. That person and that future were real to me, and they are gone, and no court ruling gives them back. What I have instead is this: a porch in Asheville, and mountains going orange in the evening, and a cup of coffee, and a folder on the table beside me, and the knowledge that the work I did for 31 years is still standing, still running, still employing 60-some people who come to work every morning and do good work. I have a brother in Knoxville who answered the phone on the second day and drove 4 hours without being asked. I have an attorney who is very good at her job and believes strongly in what she is doing. I have, at 64, more clarity about what matters and what doesn't than I have had at any other point in my life. I used to think that building something meant you were leaving a piece of yourself behind for safekeeping, that if you poured yourself into something, a company, a family, a name, it would hold that piece of you and carry it forward after you were gone. I do not think that anymore. I think building something is its own reward in the moment of the building. The thing you build may last or it may not, and the people you build it for may honor it or they may not, and none of that is under your control. What is under your control is the quality of the work while you are doing it, the integrity of the material, the care you put in where nobody is watching. My father taught me that. He was a plumber, like me. He used to say that the best work you do is the work in the walls, where nobody ever sees it, because that is the work that holds the building up. I have lived by that my whole life. I intend to keep living by it. Next Thursday morning, I will drive from Asheville to Charlotte. I will walk into the conference room on the 14th floor of an office building downtown, and I will sit across the table from my son for the first time in 14 months. I do not know what his face will look like when he sees me. I do not know what I will feel when I see his. What I know is what is in the folder. And this time, I am the one holding the pen.